ourselves, and some of our colleagues might not have been there when this matter arose. The background.
You're muted, Chair.
Okay, please don't Shanaz, please don't mute me. Okay, the background of this is that after the appointment of Professor Mbati, I think it was sometimes last year, as the Vice-Chancellor of Sefako Makgatho University, we started receiving complaints. We received a complaint from the Higher Education Transformation Network, and we received other complaints as well. And we we then decided to ask the questions. And then we had an engagement with the Commission on Gender Equality. And after that, we felt that the matters requires that we must get into a detailed process of the committee to probe all these matters that relates to Professor Mbati, both during his stint as the Vice-Chancellor of the University of Venda, as well as the process that led to his appointment as the Vice-Chancellor of Sefako Makgatho University. So members will remember that there were quite a number of exchanges, letters from the lawyers and so forth, which we had to deal with and ask our legal services to deal with, which led to the adoption of the revised terms of reference, which are making it explicitly clear. It has not always been our intention to probe matters that have been finalized by the court. But we felt that since there is a serious concern around whether the committee wants to open those matters, just to make sure as part of our terms of reference that such will not be the case. So we adopted the revised terms of reference, and now we are proceeding in line with that. Basically, our interest is to inquire as to whether the university implemented its own policy, particularly the sexual harassment policy at the time when the allegations came. We're interested in how these allegations were handled within the university itself. And of course, there's been a number of allegations that have since been made, some of which there's a report from the department on how the university handled the infrastructure projects, which we also intend to deal with with those issues that are arising from that report. So basically that is that, members, just to refresh ourselves and to get back to the actual purpose of this process. We are fully empowered in terms of the Constitution and the rules of the National Assembly to inquire into any matter that is before the Portfolio Committee. So what we are doing is fully in line with the Constitution and the rules of the National Assembly. Now, we had identified a number of witnesses. We had written to those witnesses requested them to give us the witness statements. Most of the witnesses have cooperated with us. Unfortunately, when we were planning for today or for this week, we had to consult the witnesses because we had to inform them that they have to come. Now, I must say that some of the witnesses, in particular, two of the former chairpersons of council, Mrs. Shirley Mabusela, I think, and the other former chair, have indicated that they are not willing to come and participate. Unfortunately, we received that late. We couldn't act on it on time, but we felt that it should not stop the process. Let's continue, and then we'll find mechanism to get them to come and testify at a later stage. It's important that we hear their version because they were in charge of the University of Venda at that time as chairpersons, and they were exercising public power, utilizing public resources, and they are duty bound to come and account on the actions that they've taken during their tenure. So they will not be doing us a favor. They will be coming here to account as per the requirements of those who are holding public office. So that is that, members. Of course, there are other witnesses who are coming tomorrow and on Friday. So today, because of the unwillingness of those that we have identified to come, I think two. So we're only left with the chairperson of council, the current chair. But we think that the current chair should be able to, on behalf of the university and the university council, to answer some of the questions that we might be having. So that is how we are going to be proceeding today, honorable members. I have not received any apology except that Honorable Makgatho has indicated that she will be joining us a little bit later. I haven't received, I don't know whether Anele, have you received apologies?
No, Chair.
Okay. So no apologies for this meeting.
Honorable King.
Honorable.
Dr. Lottridge will be joining us a little bit late. She's got another matter that she's dealing with.
Okay, thank you. Dr. Lottridge will be joining us a little bit later. Those are the only apologies that we have. Now, just to deal with the house issues, because we will be having quite a long day today. I hope that members have received the draft questions that we have been assisted with from the side of the research team. We received them a bit late yesterday, so I asked that they must be distributed to the members. I hope members do have those questions. Now, it has always been our intention that we should, as much as we can, try and have some structured, process wherein, even though we understand that members are free to ask whatever question they would like to ask, but at least for our purpose, we should extract the kind of information that we would like to get based on the witness statements. So these draft questions have been drafted by the research team to try and guide members that based on their own analysis of the witness statements, these are the type of questions that we feel are relevant that should be asked. And if there is any question that gets asked and it then gets into the merits of or the issues that were ventilated in court and were resolved in court, I have got the responsibility to guide the meeting to make sure that we do not enter into that space. So I hope that members have received this question. Now, I was trying to figure out how we are going to allocate the question. The one way of doing it is to say question one will be allocated to this member, provided that the members are indicating their willingness or their intention to engage or to ask questions. So I see Honorable Letzia's hand is up. Maybe let me just take the hand and Honorable Tambo. Let me take these two hands just on the procedural issues on how we will be asking the questions and the draft that has been provided to us. How can we utilize that? Honorable Letzia.
Thank you very much, Chair. I'm struggling with network this morning. They are fixing the Wi-Fi issue, and I apologize for not putting my video on. Once it's done and we've started fully, I will be putting it on. Hopefully before 10, they will be done. Chair, I wanted to react to your opening, especially on the part that the two former chairpersons of council have decided not to participate in this process. In simple terms, they've just shown Parliament and the middle finger. So I just wanted to to react to that, Chair, and put it to the platform that even to them, if they're watching now, that Chair, we must subpoena them, as we are empowered by the Constitution of this country and the rules of Parliament. It can be that people accept public office and decide whether they want to account to the people of this country on how the resources of our public institutions have been used, and whether those people, whilst holding office, followed or did everything in line with the Constitution of this country. So I'm putting it here, Chair, that we must subpoena them as early as possible, because it can be, we must also send a strong message to everybody else in other councils of public institutions and in board members of public institutions, that you don't do as you please, and that when you are supposed to account to the people of this country, you come with excuses. I'm very disappointed, especially with what is the lady's name, Mabusela, the former chair.
Yeah.
Because I even saw the letter that she had written to us last year before we postponed. I felt that she would have assisted the commission, to get into the bottom of this thing. Well, I did not appreciate, I did not agree with her, the tone she used there, and I was hoping she will come so that, we can put people to task based on what they've done and what they are saying. But if they are running away will be left with no choice but to subpoena them, Chair. And I think we must subpoena them. Yes, I hear that they indicated to the committee very late that they will not be coming, and we could not do that. But I think next time, when we send them an invite next time, including not only them, including other witnesses, maybe the invite must be coupled or must be accompanied by a subpoena so that the time, we don't waste the committee's time next time. Thank you very much, Chair.
Okay, thank you very much, Honorable Litsia. Honorable Tambo.
Thank you very much, Chair, and greetings to the members and the Chair of Council. Just on the matter of the questions, the draft questions submitted to us, I think it's a very progressive assistance from the research committee. They are extremely relevant questions and they can assist us, especially those of us who have entered the process at a bit of a later stage, to understand and grasp the nature of the issues confronting us in this inquiry and how we must guide our thinking and line of questioning. I don't think, however, it is fruitful for questions to be allocated to members in a stringent manner. I'm just intervening on the suggestion you seem to be making. I don't think it will be fruitful because I think we must base our questions in line with what the research committee has submitted to us. But I think we must also be allowed to craft those questions in a particular way, which will be conducive to how a member might seek to pose a question. So I'm not sure, maybe you'll be able to give further clarity on how you propose allocating each question per member, but I don't think it will be conducive or productive for there to be question allocation as per the draft submitted by the research committee in a strict manner. I think members should have engaged all documents sent to us, even though they might have come late. And I think we must have crafted an idea of what questions we're going to ask based on those research questions. And perhaps some of those research questions will be asked verbatim as well. So I think members must be afforded that space and opportunity to sort of get onto their own feet in the inquiry, especially on the first day, just to be able to own the process as well. Thank you very much.
Okay, thank you very much to the two honorable members. I think members have made quite valuable inputs, and I would like to summarize them as follows. On the reluctance by the council members, the former two chairpersons, it is the view of the committee that we should initiate a process to subpoena them and to get them to come and testify. Fortunately, we were still identifying an extra day or two to get one or two witnesses, including Professor Mbati, to come and give testimony so we can schedule them on those dates. But I think we're agreeing with the suggestion that we should subpoena them, particularly given the fact that they played a critical role during the period that we want to inquire on, especially Mrs. Mabusela, who was the chairperson of council. She was presiding over council when all these matters were happening. And so it's important that she must come and account publicly to, not to us, but to the people of this country, including the constituency there at the University of Venda, how she was managing the institution, she was governing the institution, and what decisions was taken and what informs the decisions that were taken. So we agree with Honorable Litsia that we should initiate a process. We will work closely with our legal services to undertake that process. Secondly, on the draft questions, Honorable Tambo is making a proposal that let's utilize these questions, especially for some of the members who might not have received all the bulk, all the information, because we received quite bulky documents initially, and which had got a lot of documentation. Some of the members had gone through those documentation and the witness statements. Some members might not have done so. So the questions, I've went through the questions myself yesterday, quite appropriate, so that we can plug in the holes that are there in terms of us gathering the information. They help us to ask appropriate questions and to get the right information so that we are not all over the place. But Honorable Tambo is making a good point that let's utilize them to guide our questioning, but let's also allow members some leeway to also use their own initiative to craft the questions and to pose them. We will just have to make sure that almost all the information that we require from all these questions, we're able to get it, so that we will have to evaluate at the end whether all the areas which these questions needed to cover are covered. So, but let's agree with your proposal, Honorable Tambo, that instead of allocating the questions which may restrict the members, let's give members some free rein, but members must be able to indicate when they ask the question, whether their question is related to which area there in this question paper. So that's how I'm going to suggest that we move forward. So we will ask members to raise their hands after the testimony or the presentation by the Chair of Council. And as we go through, members must then indicate that this is my question, is related to, obviously it's only members who have got this question, not any other person. So you will be directing that to me so that I can be able to note on my notes that this question has been covered, this question has been covered, so that whichever question that is not covered, I'm able to put that question through. But I just wish to request members, there is a question there that I would like to ask it myself, which is on 1.2.5. I've got supplementary questions for that one. There's something that I would like to probe from that question, which relates to the decision of Council on the 8th of July 2016. So if I may ask that members must avoid that one and leave that to me, because I've got a number of supplementary questions to that one. If it's fine with members, I think we can then invite, what we will do, all the witnesses, we will have to ask them to either take an oath or make an affirmation. So we're going to swear in the witnesses. We have asked somebody from legal services to quickly go through that process of swearing in a witness before the witness can give testimony. And I saw Fatima from legal services. I don't know whether Fatima is still on the platform, or is there any other person assigned from legal services to do that?
Chairperson, good morning. My colleague, Ms. Ngema, is going to do administer the oaths, Chair. So Pumelele Ngema.
Okay, Mrs. Ngema, are you on the platform?
Greetings, Chairperson, and thank you very much for the opportunity. Indeed,
Yeah,
I'm on the platform.
Okay, thank you, Mrs. Ngema. Before you proceed, let me just welcome the chairperson. chairperson of council. So we maybe just also to explain to him that you will be sworn in through an administration of an oath or an affirmation, and it will be done by Mrs. Ngema. And then after you have been sworn in, we can take us through your testimony. Are you fine, Chair? I saw the chairperson on the platform. I don't know whether he's still here. Mr. Leketa.
He's trying to unmute himself, Chair.
Okay. Yeah, I saw he was here. Oh.
I'm there. Can you hear me? Can you see me?
Yeah, Chair, we can see you, we can hear you. Did you hear what I said?
Yes, I did. Thank you.
Okay. Mrs. Ngema, over to you.
Thank you so much, Chairperson. Greetings to all the members. Mr. Leketla, I will ask you to give us your full names for the record purposes and the current status where you are employed in your position.
My full names are Junius Masikila Leketa. I'm here as chairperson of the Council of the University of Venda in that capacity.
Thank you, Mr. Leketla. You are required to take an oath in accordance with Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004. You are also required to appear before this committee as a witness and to answer questions related to allegations to the inquiry into the appointment of Professor Mbati as Vice-Chancellor and related matters to the University of Venda, as well as Sefako Makgatho Health and Sciences University. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it, which is false or misleading, that person commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to either take an oath or the affirmation. Which one would you prefer, an oath or an affirmation? Please say this after me. I solemnly affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
I solemnly affirm that the evidence I give shall be nothing else but the truth. And the
Thank
truth.
you, Chairperson. The oath, the affirmation has been done.
Okay. All right, thank you very much, Mrs. Ngema, and thank you very much, Mr. Leketa, for accepting to come and assist this committee in inquiring into these matters. As you know that there's been correspondence with yourself and the university, and certain questions were put to the chair, to yourself as the chair of council, and the university, and we've received your statement. So what we would ask you to do is just to take us through the account of the university and yourself as the chair on behalf of council on the matters that we have asked you. And then after that, we will open for members to ask questions. And then you will then be responding to the questions by members. Over to you, Mr. Makgatho.
Thank you, Chairman, Chairperson. Good morning to all the members, honorable members. I, on behalf of the university, thank you for giving me the opportunity to come and account and to respond to the questions that you forwarded to the VC's office and to myself. I think firstly, I'll just to note that I assumed my chairmanship just over a year ago of the university, and the issue that will be dealt with, some of them precede me, but I think to the best of my ability, I've tried to investigate a lot of them, and where I'm able to, I will give you the appropriate answers. I'll also to refer to the fact that I think a detailed file was provided to the members, I think June or July of last year, and in my report, I will be referencing to some of those files that have already been provided to yourself. I also have one of the executives from the university with me, I think Mr. Eric Nemikula. Now and then where I at the question stage anyway, I might ask him to come in and give substantive responses. I now proceed to read the response. I'll start by referencing to the questions and then go back to give our full response. The document I'm reading reads as follows. Responses to the Portfolio Committee on Higher Education, Science and Technology Oversight Inquiry into the appointment of Professor Peter Mbati as Vice-Chancellor of Sefako Makgatho University and related matters. I'm required to respond to paragraph 3 of your letter, which raises the following allegations. 1, failure of university management to implement sound financial and supply chain management processes.
All right.
Manage the institution, including various infrastructure projects. 2, the improper manner in which the Council of Univen processed a sexual harassment complaint against Professor Mbati by Professor Pendler, a former employee of Univen, that he sexually harassed Professor Pendler, who was also an employee of the university. And finally, the fruitless and wasteful expenditure related to the use of external service providers and legal consultants. Those are the 3 questions that have been posed to us, and I'm getting to the response. Response to paragraph 3A of your letter has been tabled as follows. Paraphrase, failure of university management to implement sound financial and supply chain management processes and to properly manage the institution, including various infrastructure projects. The response, this matter has well been dealt with during my initial submission to the Portfolio Committee as follows. 1, the university submitted that management did implement sound financial supply chain management processes in that 1, all financial transactions were done within the limits of the university's management. All tender processes in respect of all infrastructure projects were done in compliance with the university supply chain management policy and that the institution was properly managed. The university further submits that the university management did manage various infrastructure projects from the tender process until implementation stage. The council was, however, made aware of certain weaknesses which were raised by the external audit report, in respect of which the university appointed a company to investigate the alleged weaknesses relating to procurement process followed for the identified infrastructure projects. To briefly summarize the facts, I report as follows. During 2016, Susan Saluba Kuboto, the then external auditors of the University of Venda, produce a report entitled Project Review Report to those charged with governance. In the report, it outlined various weaknesses in the governance of 14 different projects whereby supply chain management processes were not adhered to. The report concluded by recommending that forensic investigation be conducted on this project. The university vendor then appointed next SABNT, a forensic investors company, to investigate the affected projects. The primary objectives of the investigators were as follows. One, to determine whether the supply chain management policy has been breached at any stage in this project. Quantify the level of non-compliance. And thirdly, identify the individuals responsible for the non-compliance. They also had to recommend appropriate action, and this is included in my report that I submitted to you. I think FRO 1, page 1 to 228. This is submission that was made earlier last year. The forensic investigation report revealed that Dr. Jani Zaman, Deputy Vice-Chancellor Operations, Mr. Richard Ramupudu, Head Supply Chain Management, and Hulisani Nasani, Director of Facilities, should be held accountable for non-compliance with supply chain management policy in respect of 10 infrastructure projects that were under investigation. Again, I refer you to page 24, item 2 of file 01. In order to rectify the weaknesses identified with regard to non-compliance with the supply chain management policy, next SABNT recommended that disciplinary action should be considered against Dr. Jani Zaman, Richard Rampudu, and Pulisani Nesani. The university, however, found that the 3 affected people were no longer employees of the university. A legal opinion, which is attached on file number 2, page 1 to 3, was then sought, which provided as follows. The university should not consider this hearing against Jani Zaman, Richard Rampudu, and Holisani Nesani, as they were no longer university employees, and hence the university's disciplinary code for staff members was no longer applicable to them. Secondly, it was also not possible to open criminal or civil cases against the above-mentioned individuals, as they were only held liable for non-compliance with supply chain management policy, with no element of criminal activities or fraud, corruption, or personal gain. In light of legal opinion, the university then took a decision to close the matter insofar as the consequence management or disciplinary process or criminal or civil cases were concerned. In running the tendering process, the university had to rely on the expertise of quantity surveyors who were external from the university, whose advice was independent. As it relates to the affected services providers who were fingered in the forensic investigation report, as those who contributed leading to the abandonment of this project. The university implemented the forensic investigation report recommendations by terminating the service of the following service providers. The first ones are Didali Quantity Surveyors, Mutaki Direct Track JV, Tico Nivutali, and Aspire Architects. On the issue of abandoned projects, the university did a presentation to DHEAD, furnishing reasons leading to abandonment of projects, and the reasons were acceptable, and hence DHEAD continued to fund those projects to their ultimate completion. I want to conclude by indicating that in the entire next SABNT forensic report, there was nowhere the report made mention of Professor Mbati regarding the allegations of mismanagement of the university, improper management of infrastructure projects, acts of misconduct, or abusing his power for personal gain. While still on this issue, during 2018, the university was summoned to appear at the office of the South African Directorate for Priority Crime Investigations, organized crime, economic crime, corruption, and other serious crimes, paraphrased as the Hawks. The university was called upon to submit all documentation relating to all the tenders that were identified by external auditors and subjected to forensic investigation, and all such documents were furnished to the Hawks officers. It also came to light that the case to Hawks was reported by some former University of Venda staff members who were dismissed for misconduct, and they are also amongst the witnesses who are to be called before this committee. The projects in question were investigated by the Hawks, and the university was cleared of allegations by the Hawks. The matter was dealt with under inquiry number 05/09/2018 in Polokwane. That's a reference case, I suppose. Finally, there was no failure on the part of Univen management to implement sound financial and supply chain management processes and to properly manage the institution, including various infrastructure projects. I proceed to the next question. Response to paragraph 3B of your letter has been tabled as follows: allegation of sexual harassment. The matter of Professor Pence's sexual harassment allegations against Professor Mbati have a long, litigious history and had made its way through to our various courts up to the Labour Appeal Court. The Labour Appeal Court ultimately dismissed Professor Pence's petition to leave to appeal in 2018. To briefly summarize the facts as follows: how Univen branch raised allegations of fraud and corruption against certain university officials relating to an 18 million tender bribe in the appointment of a company called Clean Shop for the provision of cleaning services at the university campus. The university then appointed an audit company, Deloitte, to conduct forensic investigation, and the recommendation were that some identified staff members should be subjected to a disciplinary inquiry, and Professor Pender was one of such identified staff members. Again, see a documentation on file number 8, page numbers 1 to 27. The investigation revealed that Pender was approached by the Clean Shop as potential service providers, and that Clean Shop paid her money to influence the University of Venda's Council, in which she was a member at the time, to award the contract to the service provider, the service provider being Clean Shop. It is worth reiterating that investigators fingered Professor Pender and others for the impropriety, and this led to her being charged, disciplined, and dismissed on account of misconduct. Professor Pender then declared unfair dismissal dispute with the CCMA, contending that her dismissal was not motivated by misconduct she had later committed, but it was as a result of sexual harassment. The CCMA ruled that the matter is one of automatic dismissal to be referred to the Labour Court. Professor Pender then escalated the referral to the Labour Court as an automatically unfair dismissal, as Professor Pender claimed that she had been unfairly dismissed on the grounds of sex. It was also at the stage that she informed the then Chairperson of Council, Ms. Mabusela, contending that she was sexually harassed by Professor Peter Mbati, and hence her dismissal. That's when and how Council became aware of Professor Pender's sexual harassment allegations. The matter concerning Professor Pender allegations of sexual harassment was duly considered by the University Council. During 2011, Council, at upon receipt of Professor Pender's complaint letter addressed to the Chairperson of Council, appointed Levry Modise, mediator, to investigate and mediate the matter between Professor Pender and Professor Mbati. The outcome of the mediation report, however, only indicated that the mediation had reached a dead end without providing details on the legitimacy or others of Professor Penda's complaint. Again, refer to a report, I think, which is dated the 3rd of the 11th, 2011, document number 5, pages 31 to 33. By that time, Professor Penda had also reported the matter to the Commission for Gender Equality. She also opened a criminal case of rape against Professor Mbati at Tuendao Police Station. On the criminal case, the Director of Public Prosecution found that there was no basis to charge and prosecute Professor Mbati for rape. Again, the documents I think are marked as PPL on the detailed file that was provided. On the other hand, the Commission for Gender Equality did consider the matter and made findings against the university without affording the university an opportunity to present its side of the story. The university took the Commission for Gender Equality report for review with a view of having it set aside. However, the matter was finally settled by way of a consent judgment. Again, that's attached on a document dated the 30th of May 2016, file number 5, page 8, which directed the university to comply with clause 5.21 of the University Policy on Sexual Harassment, which was for the university to call for the mediation report, which Levery Modis had prepared. See again, the Sexual Harassment Policy document, SH5, on pages number 9 to 18. The University Council noted, however, that although Levery Modis' report did indicate that he had a view on the legitimacy of others of Professor Panda's complaint, the report did not provide details on the merits of the complaint, and hence Council took a resolution to give Levery Modis yet another opportunity to further investigate the matter and put more flesh on its initial findings. Levery Modis did provide a detailed report 24th of June 2016 as the Council meeting reference number, dated the 24th of June 2016 on document 5, page 19 to 22. Council then sought for a legal opinion from attorneys Mike Mashiro, who was a Univen Council member and also a chairperson of the Appeals Committee. The legal opinion advised Council that there was no basis to charge Professor Mbati on allegations of sexual harassment, as the relationship between the duo was consensual. Mashiro's legal opinion is dated the 5th of July 2016, in file number SH5, page 24 to page 30. At this meeting of the 8th of July 2016, Council resolved that in view of the Modis report, to the effect that there was no sexual harassment and the legal opinion sought on the matter, there was no basis to pursue the matter against Professor Mbati, as he was cleared of the allegation of sexual harassment. Again, you see the minutes of 8th of July 2016, document number SH5, page 6, and Mashiro's report again on file number 5, page 24 to 30. The University Council further resolved that since the matter was already before the Labour Court, Council had to allow courts to make final determination on the matter, and that no further intervention could have taken place with regard to the above matter by the University Council. Again, see the minutes of 8th of July 2016, file number 5, page 6. On October 12, 2017, the Labour Court ultimately found that Professor Penda was not automatically unfairly dismissed. Paragraph, Professor Penda was not sexually harassed, and that her dismissal was both substantively and procedurally fair. See page 41 to page 68 of the Labour Court judgment on file number SH07. Agreed by the outcome, Professor Penda applied for leave to appeal the Labour Court decision to the Labour Appeal Court, which was denied. Again, we refer to the judgment dated the 12th of the 10th, 2017 on document SH07, pages 41 to 63. And the labor court judgment on Professor Pendra's leave to appeal delivered on 29th November 2017 on document SH07, pages 67 to 68. Nonetheless, in July 2018, Professor Pendra proceeded to petition the Labour Appeal Court for leave to appeal, which petition was also refused. The Labour Appeals Court confirmed that there were no reasonable prospects of success and no compelling reason why the matter should be heard. Again, with your reference to the date of the judgment, it was 15th February 2018, file SH7, page 64 to 66. The Judicial Council accepted the Labour Court judgment and Labour Appeal Court rulings and considered the matter as closed. In conclusion, it's important to highlight that the Judicial Council must only required to consider and make a determination on the issue of sexual harassment allegations as raised by Professor Pendra to the then chairperson of the Council. As already indicated above, Council that after applying its mind on the findings of Melissa mediation report and my social legal opinion, to resolve that Professor Pendra's allegation of sexual harassment against Mr. Mbati had no basis. Council further resolved to close the matter and allow the court process to unfold for a final determination. Council had comfort that the matter was properly closed following the dismissal of Pendra's petition for leave to appeal by the Labour Appeals Court, and as Prof. Pendra never pursued the matter any further. That dealt with that matter of sexual harassment. Now we deal with paragraph 3C of your letter, fruitless and wasteful expenditure relating to the use of external service providers and legal consultants. In order to address this question, it is important to first indicate that fruitless and wasteful expenditure is an expenditure that is made in vain and would have been avoided had reasonable care been exercised. This type of expenditure is incurred where no value for money is received for expenditure or the use of resources. The jurists submit that all external service providers and legal consultants who were appointed by the university were appointed because there was a need for such services, and they did render the services to the best interest of the university. The conclusion is that there was no fruitless and wasteful expenditure related to the use of external service providers and legal consultants. The supply chain management for university or vendor provides for deviations on the procurement of certain services where the estimated value of the consulting services is below the threshold of 500,000. We refer again to the copies of the policy that are attached, SPCH number 8. Clause 15 of this policy states that the standard procurement process will be bypassed and the university will dispense with the invitation for bids and quotation of bids will be obtained in a manner that it is either in the best interest of the university and not limited to suppliers on database. See the copy of the 11 pages of the policy attached again on PCH 9. The records show that the university had a database of firms of attorneys and advocates with various skills and expertise ranging from labor and civil matters. These included law firms from both Limpopo and Gauteng. On the question of the number of lawyers who were procured through deviation, the records show that the university always select a law firm with necessary skills and expertise from profiles of this database, and that all firms have been selected and appointed in the same manner. Furthermore, the appointment of all lawyers who served and those who are serving the university did not exceed the threshold as at the time of the appointment, as amounts for service could not be uncertain at the time of the appointment. These lawyers were appointed case per case and on an ad hoc basis. For the noting of the Procedural Committee, The university has already taken the decision to go out on tender with a view to appoint a panel of attorneys. All costs were within management's limits approval. On civil matters, the university used the service of Boys Dupree, Workshop Incorporated, and Wisani Barrow Incorporated. The number of lawyers handling civil matters is limited due to the fact that, unlike labor matters, civil matters involve many procedures to be followed, and the attorney has to run with the matter through various courts up to its finality. The labor matters of the university were used. On labor matters, the university used the service of the following law firms: Bowman Kilfinen, Sikita Daniel and Associates, John Siave, Advocate Ndivuse Chizeve, Advocate Mtombeni, James Chiredo Attorneys, Advocate Sikwivulu, Richard Matoba Attorneys, Manda Madima Attorneys, Advocate Sengezi Ngwana. This concludes my reading of the report. Thank you, Chairperson.
Okay, thank you very much. Let me just do this. Thank you very much, Chair of Council. Thanks for your presentation. And I think we do have that submission. All what we needed was for you to put it in record. So we will now take members who are going to be asking questions. Let me start with Honorable Tambo, followed by Honorable Boshoff, followed by Honorable King, followed by Honorable Litzie. And then I think I will also come in, number 5. Okay, for now, let me just see, am I leaving somebody? Honorable Mananiso, number 6. Okay, let's so what we will do, members, I'm going to ask and plead that as much as we can, let's avoid long preambles. Let's try and get straight to the point so that the question can be well understood. Members are allowed to make questions before they put their questions, but please let that not be very long. And as we have agreed, please just indicate your question is related to which part of these questions that have been that we have been assisted with by the research team. And again, let's avoid matters which were ventilated in court, because we have made it very clear that it is not our intention to open those matters. Okay, Honorable Tambo, so what we'll do, we'll get a member to ask the question, open up for response from the Chair of Council. Can we please agree on at least 3 minutes rule in terms of asking questions so that we are able to manage time? Okay, Honorable Tambo.
All right, thanks, Chair. No, to follow your lead, let's avoid preambles. My first questions relate to the mismanagement of infrastructure and related matters. It is alleged that Prof. Mbati tried to change the university statute to allow the extension of his contract for the third time. However, the effort failed. So the question is whether the council is aware of this allegation and what action was taken, and whether there were any exceptional circumstances to warrant that he was appointed for the third time. Secondly, as per the knowledge of the council, was Professor Mbati's relationship with Andani Holdings, which allegedly was appointed by Prof. Mbati to implement Univen infrastructure projects, a matter that council was aware of, and in relation to Prof. Mbati being a co-director of Black Capital Limited, which is a subsidiary of Andani Investments Holding Company, and was council aware of this before the finding of the Higher Education Department? And also, is it true that Prof. Mbati earned 3.9 million per annum? If so, what was the rationale for this amount, considering the number of students at the university and relative salaries of other vice-chancellors overseeing considerably more students? Furthermore, was council aware of any suggestion or allegation that Mbati used university resources to defend himself? So it's two-pronged. It relates to the sexual harassment litigation as well. Was council aware that Prof. Mbati used any university resources to defend himself against litigation in the sexual harassment matter? So the two other questions relate to the processing of sexual harassment complaint against Prof. Mbati by Prof. Pendler. Just to ascertain what due process was followed or afforded to the university, and was council aware that the adjudicator of Professor Pendler's disciplinary hearing was the personal lawyer of Prof. Mbati, and did the allegations of fraud against her by the university, just to confirm, arise after she had laid complaints of sexual harassment against Prof. Mbati? And secondly, there's a claim that Prof. Pendler alleges that Prof. Mbati was willing to settle financially with her. The CGE submission alleges that after Prof. Pendler referred the dispute to the Labour Court on the 6th of June as an automatic unfair dismissal, a letter was sent to Prof. Pendler by Bowman's attorneys representing Univen dated the 8th of December 2016, alleging that the university proposed to pay Prof. Pendler 1,300,000 rand to change the reasons for her dismissal from misconduct to mutual separation, and to give Professor Pendler a positive reference, and that Prof. Pendler withdraw the Labour Court matter and any other applications instituted against the university, and that Prof. Pendler keeps the settlement proposal confidential. In your view, Chair, since the University Council claims to have no record of a letter proposing settlement, and the same being said by Bowman's attorneys, is it likely or possible that such a letter of settlement exists, and would it be fruitful for the committee to pursue acquiring such a letter from Prof. Pendler and the CGE? Thank you very much, Chair.
Okay, thank you very much.
Thank you.
Okay, okay, you can continue. I noted 7 questions on my side. I don't know whether you've got the same ones.
I've got it. I think at the beginning of my presentation, I did mention the fact that I think I've got Mr. Eric Nemikula, who is the legal counsel for the university, and he probably has most of the answers that are there. Because I think this gets more into the detail of the matters that me being a chairman for over the last 11 months would not be very privy to that. But I think Eric will be there to help. Eric, are you there?
I'm there, Chair.
You noted the questions, sir?
I did note the questions.
Okay,
can you please respond?
Chair, can we do this? Advocate Eric Nemukula is on the platform representing the university. So you will not be able to give evidence before you have been sworn in, because this is a formal inquiry. So we do require that before you give any evidence, you must first be sworn in. So I am going to ask, please switch on your video. Advocate.
Chairperson, I had a slight issue with the network. There was an electricity cut here by the neck. I did not hear the prior indication.
Oh, okay, can open it.
Okay. Mrs. Ngema, are you still there?
Yes, I will do that.
Yes, I'm there.
I don't call me. I'm on the
Yes,
call.
Chairperson, I'm here.
Yeah.
Chair Lekgeta, please mute yourself, because when you answer your phone, we can hear what you say. I was saying, Advocate Nemukula, this is a formal inquiry of the committee, so all witnesses who are supposed to come here must be sworn in. So if you are going to address this inquiry, you will have to be sworn in before you can address any of the questions that have been put here. So can we ask Mrs. Ngema to help us once more to administer the oath to Advocate Eric Nemukula? I'm going to ask you to switch on your video, Advocate, as you have been sworn in. Thank you. Mrs. Ngema?
Thank you, Chairperson. Sir, kindly give us your full names for the record and the current status of where you are employed in your position.
I'm Advocate Abafani Eric Nemukula. I'm the Acting Director, Legal Services for the University of Venda since 2014, June.
Thank you, sir. You are required to take an oath in accordance with Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004. You are also required to appear before this committee as a witness and to answer questions related to the allegations and the information you will present in this inquiry on the appointment of Professor Mbati as Vice-Chancellor and related matters to University of Venda. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that the evidence given under oath or affirmation before a house or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a house or the committee of Parliament with information or makes a statement before it, which is false or misleading, commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take either the oath or the affirmation. Which one would you prefer?
I can take the oath, Chair.
Thank you, sir. Please say these words after me. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
I swear that the evidence that I shall give shall be the truth and nothing but the truth. I raise up my right hand
Advocate
and confirm.
Thank you, Chair.
Mrs. Ngema, let me just interject a bit and ask advocates, as you take an oath, you are required to raise your right hand. I think you know, advocate. Raise your right hand as you confirm the last part of Mrs. Ngema's. Are you still there?
Yes, the Wi-Fi was coming back. So yeah, I'm here, Chairperson.
Okay, I'm saying please raise your right hand. I think Mrs. Ngema, let's do that with all the witnesses. Raise your right hand and then.
So help me God.
Okay. Thank you. All right. Which questions are you going to answer, Chair? Which ones are going to be answered by? Thank you very much, Mrs. Ngema. We can now proceed with Advocate. Chair, which questions would you like the Advocate to respond to?
I think basically all of those questions relate to more details. I think that I would not agree with.
Okay. The question about the extension of the contract. There is a question about Ndani Holdings. There is a question about the remuneration of 3.2 million, which must be answered by yourself, Chairperson. There is a question about utilizing university resources to defend, utilizing university resources by Professor Mbati to defend himself. There is a question of the presiding officer during the duty of Professor Pendler was a personal lawyer of Professor Mbati. And then there is also a question around the settlement proposal, whether it exists, whether it's a university. So, my difficulty is that Advocate is the employee of the university, and he can only explain matters which are there, but he was not the decision maker. For instance, he would not be able to explain this issue about the remuneration of 3.2 million. He will not be able to explain the settlement act proposal. Maybe he can do that, I'm not sure. And the issues around the infrastructure and the allegation about the request for the extension of the contract of Professor Mbati. But let's start with you, Chair, and see which questions can you respond to. Maybe let's start with the.
I've read through all of them actually. They are very detailed type of questions that would have been dealt with specific meetings. That is why I thought Advocate would have been the best. He was an official and officer of the organization and would have dealt with those.
Okay, let's start with Advocate and the questions that he was not able to answer.
Thank you, Chairperson. I and all honorable members of Parliament, and greetings. I want to start with the allegation around the attempts by Prof. Mbati to influence the extension of the contract by way of maybe having it included or amending the university statute. Chairperson, I want to indicate that for purposes of the review of the university statute, there are various processes that must be followed. There are various governance structures that are involved in this process. First and foremost, we do have the Senior Management Committee, which will do the proposed amendments, and we do have the Executive Committee, which will also make inputs. We do have the IF, which is in place, which will also assist. We also have the Senate, which also have an input, and there is EXCO, there is also a Council. So it is very much difficult for one to influence the process in an instance where the process has to go all those governance structures up until the council approves the statute, and to the extent that it is sent to the department for approval and gazetting. So the university does not have the allegations of him or of Prof. Mbati having to attempted to influence the amendment on the statute to cater for the extension. And even if that has happened, it would not have been possible in view of all the governing structures which the statute or the amendment should go through. Number two, there is an issue around Andani Holding. Yeah, indeed, this matter came to the attention of the university and the university council, and council had to investigate this matter to check if indeed Prof. Mbati was one such director of Andani Holding, and there was no such information that could be obtained. So I can safely say the university does not have records. It has the records regarding the allegations and which were investigated, and we could not establish any relationship between Andani Holding and Prof. Mbati. He was not amongst the directors of Andani Holding. I will omit, Chairperson, the issue of 3.2 million per annum for Prof. Mbati. Chairperson?
You must understand that it's going to be interactive. We're going to interject on matters which we want elaboration.
No problem.
Or you say that the university investigated and they found out that Professor Mbati is not a director of Andani Holdings. Who were the directors, if I may ask?
Chairperson, I do not have the records now because we never anticipated this question, Chairperson, as it was never part of the pack of questions which came. I think I'm coming across this question for the first time, and given the opportunity, even after this meeting, I can supply the honorable committee with such names of the directors. I don't have the names readily available, Chairperson.
Sorry, Chair.
Honorable Tambo?
Yeah, just to caution the legal rep of Univen, you can't then speak unequivocally and declare with confidence that Prof. Mbati did not have a relationship with Andani if you don't have knowledge or documents to assist yourself to respond to questions such as the one that the chair has asked right now. Because the way you were speaking, you spoke confidently that the university has found no link between Prof. Mbati and Andani. But the Department of Higher Education found that Prof. Mbati was a co-director in Black Limited, which is a subsidiary, Black Capital Limited, which is a subsidiary of Andani as a holding company. So there's a relationship there. And the question of the chairperson becomes extremely relevant when one considers that a personal assistant of Prof. Mbati, her son, was a co-director in Andani as well. So the confidence that you declare that the university made no link between Andani and the Vice-Chancellor must be toned down because you're speaking under oath, and you must be able to have been furnished to have access to relative information before you make such declarations, because you're speaking on behalf of the university right now. And I think we must caution you and advise you of that before you declare with confidence that some things are invalid or some things have not occurred. Thank you, Chair.
Okay, thank you. Advocate, what do you have to say to that? Advocate?
Sorry, Chairperson. I was muted. Chairperson, I think Honorable Tambo is correct. Like I indicated, Chairperson, I said that we never anticipated this question as it was not part of the questions that were initially submitted to us. But I can indicate, Chairperson, that given the opportunity, like I indicated, I can look for the documents and be able to furnish the Honorable Committee in line with this question, Chairperson.
Okay, I'm becoming to have some difficulty, Advocate. These allegations are contained in the report by the department, which we shared with the university. The university has got that report, which makes this allegation. These questions were put to the university. These questions were put to Professor Mbati himself. So for you to say that you are not aware of this allegation, I don't think it's going to be helpful for us, because these allegations are related, that Professor Mbati was the director or related to Mbati. Are you listening, Advocate?
Listening, Chairperson. I'm listening, Chairperson.
I don't know what's happening where you are.
No, there was a printer which is making noise here, so I was switching it off, Chairperson. Sorry for that interruption, because I could no longer hear you. You may, but I've heard you, Chairperson, indicating that you have a difficulty since, well, the issues were submitted to us, but indeed, they could have been submitted to us, but for purposes of preparation for this sitting, we have gone through all the questions that were posed to us by the portfolio committee. We did not find that, and that is why I'm saying now that this is the question which is coming from the floor, we may, as the university, be afforded an opportunity to go and really look into this specific matter and come back to the committee.
Don't recite what you have just said. Please, is your mic or is your speaker on? Because you keep on talking when I'm interjecting. So it looks like you don't hear what I'm saying.
Yes, I think I'm having a bit of difficulty in hearing, but now I can hear you, Chairperson.
All right, please, when I interject, please just stop. Don't continue to recite what you have just said. Maybe let's put the questions like this. Do you know who's the director of Black Capital, Pty Limited?
Sitting from where I am, Chairperson, I don't know.
Okay.
We do not have the records, yeah.
Is it true that Mr. Lindelani Qivi, who's the son of Mrs. Grace Qivi, who was the personal assistant of Professor Mbati, is the director of Pandani? Is it true or is it not true?
I cannot confirm, Chairperson, unless I have visited the documents.
Okay. Is it true or is it not true that Black Capital is a subsidiary of Andani Holdings?
I will have to be afforded an opportunity, Chairperson, to look into the matter.
So you can then conclude, based on what you have just responded, that Professor Mbati is no way related to Andani Holdings, because you can't confirm who is the director of Black Capital and whether Black Capital is a subsidiary of Andani or whether Mrs. Qivi's son is a director of Andani. That you can't confirm.
Yeah, those are not the records we have in front of us as the university.
So we can conclude that you are not able to answer that question comprehensively. Whether
yes, yeah, but Chairperson, you will have to note that I've made a submission that I came here unprepared.
Advocate, please just listen to me and answer the question that I'm putting to you, and don't speak before I finish speaking, please. I'm saying you are therefore not in a position to comprehensively respond with facts whether Professor Mbati is not in any way related to Andani Holdings?
I do not have those records now, Chair.
So you can't answer for that question.
Yes.
Okay. So let's leave that one because I think you have just confirmed that you can't say for sure whether Professor Mbati is related or was related to Andani Holdings because of those facts. Can we move to the other question?
I have noted, Chairperson, question number 3.2 as the one for Prof. Mbati's remuneration, and I indicated that I will reserve that for the Chairperson.
Okay.
I can proceed to question number 4.
Yeah.
And I don't know if I've recorded correctly as number 4, but here the question is about Mbati, or the allegation of Mbati having used the university resources to defend himself against the sexual harassment allegations. There are two things I want to indicate here, Chairperson. One is that when this matter came up, and as you recall, Chairperson, that this matter arose from the allegations of misconduct. There was a disciplinary hearing, and the matter proceeded, it was dismissed, and the matter proceeded to the labor court. The university believed that it had a prima facie case against Prof. Pendler, and hence the university had to defend itself going forward in terms of the labor processes and labor court processes. And the second issue, Chairperson, as you would have noted when the Chairperson was reading out the university responses, he indicated something to the effect that Prof. Mbati and Prof. Pendler reported the matter to the CGE, and the CGE proceeded to make a finding against the university without having afforded the university an opportunity to present its side of the story. So indeed, it was incumbent upon the university to clear its name, and hence the university had to take the report, the CGE report, on review. So apart from the two processes which I have indicated to the Chairperson, there are no other processes in respect of which the university has, or Prof. Mbati might have used the university resources to defend himself against the allegations, Chairperson. Those were the only two processes, being the labor court up until labor appeal court, and the CGE, in respect of which the Chairperson has already made presentation. Chairperson, may I proceed to the next question?
Let's say, maybe you seem not to understand, to have understood the totality of that question. The question is about utilizing the resources of the university to defend itself, not only on the matter of Professor Pendler, it's on other issues as well, which were raised by the witnesses. The crux of the allegation, let me just explain to you what is the crux of the allegation. The crux of the allegation is that Professor Mbati utilized the university, the resources of the university, to act against those who were not agreeing with him, and he utilized the lawyers to get rid of them. And also Professor Mbati utilized the resources of the university to defend himself against action by those who were aggrieved, either with him or with the university. Now, the case in point, if I may elaborate on that, there was an application by Professor Mbati to the, I think it was the Venda High Court by then. I don't know whether it is still called that, to review and set aside the report of Mr. Mudisi. Now, Mr. Mudisa was cited as a respondent. Professor Pendler was cited as a respondent, and the University of Venda was cited as a respondent. So he was litigating against his employer. Now, it is alleged that he utilized the resources of the university in that application. Can you confirm that you did utilize the resources of the university or you did not?
Yeah, Chairperson, and thank you very much for having elaborated the question further, because when I answered it based on as it is and the way I heard it. But the first point Chairperson has raised relates to Prof. Mbati having utilized the university resources to act against those who did not agree with him. I am not aware, and as the university, we are not aware of this. As for whoever that was dismissed or subjected to the disciplinary process of the university, there were prima facie case, they were required to respond. And if they were dismissed, if I'm correct to refer to that, they were dismissed in accordance with the labor law of the country. And that was not, and that cannot be said that it was Prof. Mbati using the resources of the university to act against those who acted against him. And it is normal, Chairperson, that if one is aggrieved about the decision that has been taken by somebody, if you are not happy, you may have to say something. But I can tell you, Chairperson, that if it's about those who, I only know of those that were disciplined, subject to disciplinary processes under Mbati's era or Prof. Mbati's era, and the processes were done in line with the labor laws of the country. And secondly,
just
there's an issue.
Advocate, please, let's not be general. Can you please answer the question that I raised with you, which is a direct question, whether in approaching the court, launching that application against the report of Mr. Mudisi, and citing Professor Pendler Mudisi and the University of Venda, whether you are not alone there in the room, and the person who's in the room is causing a disturbance.
No, I was saying she must put off the phone. It was making noise, Chairperson. I just called her to switch off the phone. It was, if you could have heard, it was ringing.
Yeah, but you are not taking. Yes, you're supposed to be alone in the room.
I am alone, Chairperson.
Yeah, but there's a person walking up and down there in your room.
No, sorry for that, Chair. It was my secretary bringing some few documents which I requested. But sorry for that.
Yeah, but you can't request document in the middle of you giving testimony. That's out of order. You can't do that. You must answer the question, be in a place that is quiet, where connectivity is stable, where you are able not to have any other disturbance. Now, somebody was just passing through, answering the phone. I mean, that's very disrespectful to Parliament.
No, sorry, Chairperson. Sorry for that. Sorry for that. My apologies.
Answer my question is, are you aware or you are not aware whether Professor Mbati utilized the university, the resources of the university to launch that application in the Venda High Court?
Chairperson, you will recall that subsequent or before that you have mentioned there are 3 or 4 things which I have noted. One is when Prof Mbati acted against those who did not agree with him. That's the first point. The second point.
The questions that I have asked now, leave those things.
Okay. As it relates,
these contextual issues, to say this question, you can't just answer it making a general statement, because there are specifics here, and I've asked you about one specific case.
Sorry for that, Chairperson, but when you lay the basis, you have mentioned these 4 things. But as you indicated, I will shoot straight to your question. The university only came to know when the application was being made by Prof. Mbati. But the university was never defended that matter. It was only for Professor Mbati himself. He only furnished the university with the review when we were busy with the preparation of this matter. We learned of the judgment against Levrim Dise, but as the university, we never defended that matter. So there were no resources utilized.
No. Which question are you answering, Advocate?
Chairperson, you asked me to say, is the university aware of an application to the High Court? And I think it relates to Levrim Dise.
No, you are not listening to me. You are not listening to me, Advocate, and you must concentrate when you ask questions. I'm asking a question about a specific case that has to do with utilizing the resources of the university. I'm asking you whether, are you aware whether Professor Mbati used the resources of the university to launch that application or not?
Which application, Chairperson?
The application to the Venda High Court to set aside the report of Levari Mudise. And I'm telling you, there were 3 parties which were cited as respondents.
Yes, we were aware of the application as we were cited as the interested party.
I'm asking you whether are you aware whether Professor Mbati utilized the resources of the university or not?
He never utilized the resources of the university, Chairperson.
Are you sure?
Yes, I'm very certain.
Are you 100% sure? If we can follow up on the legal cost of the university, are we not going to find that the university has paid for that application?
No, there isn't. I can confirm, Chairperson.
Okay. Let's proceed. I think it's a matter that we have to verify. But with regards to your general responses, I think it's going to be helpful if you are specific.
Correct.
One matter that you were specific on is on the issue of the resources that were used by the university to take the report of the Commission on Gender Equality on review. That we are
correct. Yes.
Now, when Professor Mbati was defending himself against these allegations, because these allegations were personal allegations against him, whether in his defense, did he use the resources of the university or did he not use the resources of the university?
I want to get an understanding, Chairperson, when we speak of the resources of the university. I'm afraid just to shoot straight, but I want to understand if we were to talk of the resources, what could that be for clarity purposes?
The lawyers which were employed by Professor Mbati to defend himself, who paid for those lawyers?
Come again?
The lawyers who were appointed by Professor Mbati to defend himself, who paid for those lawyers?
For the review application?
No.
Okay.
The review application was launched by, which review application are we talking about?
The Levrim Dise. No. Isn't it on the CGE? We are agreeing that the university used the resources there. On the CGE one, it is the university. So on the...
whose phone is ringing there?
It's my phone, Chairperson, in the office. Can I just unplug it? May I just unplug it, Chairperson, or I change the venue?
Switch it off. Why can't
These comrades are unprepared.
Is not assisting us. Can the chair answer this question?
Chairperson, I'm back. It is now off.
Let me
I
tell you,
put it off.
we are now employing members of the portfolio committee because you are so unprepared, you are not so focused, you keep on missing the questions that we are asking you because you are being distracted. There's still some noise there. I don't know what noise is that.
No, there is no noise now. It is very quiet here. I'm alone.
Yeah, no, you look so unprepared, I must tell you. But anyway, just finish answering the question. My question is, please listen very carefully. If you can sit still, just sit still. You know, don't touch the papers there because they are making noise. You can't hear what I'm saying to you. I'm asking you, can you confirm to us whether in defending himself, appointing the lawyers who were acting for him in his defense of the allegations that were against him, Professor Mbati did not utilize the resources of the university? I'm asking you that question.
There seems to be, your voice is fading, Chairperson. I could not hear you properly. The voice was fading a bit.
Chair.
Hey, we've got a problem here.
Can I, Chair? I think advocate there has got a feeder device. It's as if he's watching on TV or he's watching or something. But there's a feeder. Even when I'm speaking here, it highlights that I'm speaking, but it also highlights his picture there, showing that there's a secondary sound. You see, shows that there's a secondary sound. You can hear me not on the device that is connected to it. It's another device. So can you switch off that device because he can't hear? He's not going to hear. Can you switch off that second device and concentrate on this one so that we can have progress? Thanks, Chair.
Let's try once more with you, advocate. Please, our time is so precious. Don't waste our time. I'm really pleading you. You know that you are supposed to be connected on one device. There is something that is echoing wherever you are. You might be streaming something live because this proceeding is streaming live. But there is an echo there. You pick it up when you. Can you switch off whatever other device that is there and then just leave this one?
No, I'm fine, Chairperson. There are no other devices now. I can confirm.
So there was another device there?
No, there wasn't. I used the desktop. It is even off because since the electricity went off, it is just showing that it is on, but it is not on.
Okay, can you switch off?
I'm not sure why the advocate is misleading us. He's with the chair of council there, I think.
No, sorry. I'm in my office. I'm in Joburg. I'm in Johannesburg. I've actually raised my hand, Chairperson.
Okay, let's do this. I don't know why
I've raised my hand.
Yes, I'm gonna give you an opportunity. I don't know why you are laughing, advocate, but you are really wasting a lot of time. You are unprepared. You see, there's still an echo now as I'm speaking. You've got two devices connected and they're making an echo wherever you are or close to where you are. Until and unless you deal with that issue, you are going to be, you see, there's an echo now. Just switch off your mic and then let me give a chairperson of council an opportunity there. But okay, let me just make this appeal, whoever that is coming, or to the both of you, person of council. Mr. Advocate, please switch off your mic. Switch off your video as well. Hey, Chair, your resource from the university, Advocate Eric Nemukula, is not prepared. There is an echo coming from wherever that is sitting. There are people distracting him. There is a secretary going up and down there. There is a printing machines that are distracting him. He looks like he's not ready for this. Because when you come here, you get to a quiet room where there's connectivity, where you are going to be speaking to us uninterrupted or without any disruption. Now he can't even hear what the questions that I'm putting to him. I have to repeat. And really, this is not on. So you might have to answer the rest of the question because Advocate there is just not prepared, you know, to come and participate in this inquiry. You said you raised your hand. I'm now giving you.
Okay, thank you. I think your comments have been noted, Chairperson. Obviously, the difficulty that I have was that speaking for myself, at the beginning of the meeting, I did mention the fact that I have been on this position since late February last year. And this matter of sexual harassment came to my attention only in July when I had to respond to it, 2020. Obviously, there are a number of things that are more detailed than what could have been given to me at the time when I was briefed about the matter. Rather been much more fairer for me was that if there are any questions that members are aware of that they needed me to address, I have no problem if those details were given to me, because at the moment, there are 3 questions that I responded to, and I can respond to them. The details of those may be more superficially. Obviously, the members have more in-depth knowledge of this matter as they have deliberated upon it a number of times. So it would be very unfair for me to try and have guessed some of the issues and give you incomplete information. As we proceed with the questions, I'll rather deal with what I'm aware of. And if there are any more questions that are going to be of this level of detail, I prefer that they be maybe forwarded to myself, and I could, through the office of the VC or at the university, try and get more information. It's actually more helpful for me to participate in a more meaningful way. At this moment, I think it's going to be no, I don't know this, I don't know that. Now, I don't think that's what we achieve. We want questions to answer. We're aware of those questions, but if there are any other further questions that are detailed, the details of which are not what I've covered in my presentation, I'll be happy to be forwarded those questions and I'll attend to them. Otherwise, we're going to have this challenge that we have now. I thought my backup had more information than I do. Now we have a challenge.
Okay.
Thank you.
No, I think, Chairperson, you're making a valid point that some of the matters are outside of your personal knowledge. That's why we've also invited the other chairpersons, Mabusela and the other chairperson who were there when these matters were happening. So you are here to represent the university correctly. You can answer to the best of your ability. And if there's something that you don't know, you may not be able to answer it. But we would have expected that before you come, there is some level of preparation, some consultation with the documents, and those people who were there, so that we can respond on the basis of what has been put to you, what you have been given as information, in line with all the questions that we raised. But we are going to be fair to you. If there is a question that you feel that you don't have any knowledge of, we will move and then we'll note that question as not having been answered. And then we will ask the relevant person to come and answer for that question. But also what worries me is the fact that you brought in a very junior official who's not part of the executive management team of the university, who came here ill-prepared, who's just all over the place, who's answering questions in a general manner without getting into the specifics. And you know, I don't want to make any conclusion about whether he's defensive or what, but all of us can see that the advocate is ill-prepared, but also the level at which he is, I'm not sure whether he's a member of the executive management team. I doubt, because he says he's a director. You know, if he was the vice-chancellor for this and that, and then or the vice-chancellor himself. And then, you know, we know that we're dealing with a senior person at the university who sits in the executive management team of the university, who understands what's happening. Not some junior official down the line who can come and give us the general denials. We don't want general denials. We want the specifics. So there's the difficulty that we are sitting with the Chair. But I am going to proceed with you. Now, just on the 7 questions raised by Honorable Tam, because I want us to conclude them. There are more questions members are having. Now, maybe Chairperson, maybe if you can indicate to us that you only became a member of council when you were elected the chair, or you were a member before, and what was the period of your membership? You are muted now. Unmute yourself.
I only became member of this council February of 2020.
Oh, okay. No, that is recent. Mm-hmm. So the issue of utilizing resources of the university to defend himself against Professor Mbati. Maybe if I may put the question to you. Are you aware whether or not Professor Mbati appointed lawyers to defend himself personally for the allegations that have been brought against him? Allegations not against the university, but against himself. Are you aware whether he has utilized the resources of the university or not?
I'm not aware of that. Let me take it further. In the first time when we responded, I did specifically ask for that information, and I was told they did not spend any money on any of his private matters. I was not even aware that there was a review of the Moody's report. I'm hearing for the first time here. But from where I took information such that I did pose it to management at the time, and I was told there was nothing like that.
Okay. So you're told by who?
Always I was in a meeting with the VC together with the legal counsel, and they advised on those matters.
Okay. Are we able to get, we've asked for the breakdown of the legal costs of the university for the past 10 years. We were given that breakdown, which is amounting to 109 million 589,185 rands. Now, this is from 2010 to 2020.
Yeah.
Now, we have not been given a breakdown of the legal cost as to who was paid. For instance, for 2010, there was 4.4 million. We don't have a breakdown of the cost of who was paid what and all of that, so that we can make our own determination whether he did not use the resources of the university for his own personal gain. And that's the difficulty that we're sitting with, which I think must get back to that issue. So let's keep that one. So let's take it that that question has not been answered of utilizing resources for personal gain.
We will revert back to you on that one. I will pursue the matter.
Yeah. I think next time, please bring the senior person, maybe the VC. I don't see, I don't know why is the Vice-Chancellor not here or any of the Deputy Vice-Chancellors. The other question is the presiding officer in the DC of Professor Pendler. There is an allegation that that person is a personal lawyer of Professor Mbati.
I would know nothing. I'm hearing for the first time also today.
Yeah. The 3.2 million, which was the salary, do you know anything?
I've got an extract of the financial statement of that particular year, 3.9 million. That's what it was for 2016. You're referring to that number?
Yeah.
Yes, 3.9 million.
So it's true that you was earning 3.9 million in 2016.
That's what it is, yeah. What I could talk about that is obviously I cannot talk about the history. What we've done now since I got onto the council, we are developing a policy that deals with these type of matters, because I think inquiries have been made, not necessarily through yourself, but a number of other forums where these issues have been questioned. Now we set up a process through which we will evaluate and assess salaries so that we can be able to substantiate that. But what happened in the past, I'm not able to account on what basis with this. There was a benchmarking issue happening here. So that process is now in place. We were able to benchmark and set up proper performance processes wherein where I sit as the chairman of council as an assessment of the VC. That's part of my responsibility.
Okay, and the last one is a settlement proposal. So that is a question from Honorable Tambo.
Yes, I'm not aware of any such proposal that was made.
The issue here is that there was a proposal by the university through Professor Mbati to Professor Pendler to resolve the matter which was before the Labor Court. And then subsequent to that, that settlement proposal was withdrawn, and there was an insistence that the matter must go through the Labor Court. So that settlement proposal was then withdrawn. So you don't know anything about that?
No, I don't know the facts about it.
Okay. So those were the 7 questions. I don't know whether members, it will still be helpful to get advocate to come and answer, because I didn't see much value in that engagement that we had with him. I don't know whether you think that we must bring him back to answer some of the questions, or we take that some of these questions outstanding, we'll have to get back to them.
I don't know whether he's still there, but I think Mr. Lambani, who's more senior, had said he might be available. And I thought by now he would have been available.
Who's that?
Advocate Lambani. He's now the registrar of the university, but I think he'll have more details.
That's the level of seniority that we require, not a junior person.
He's on the platform, Chair.
He's on the platform. Okay.
Yeah.
Advocate are able to come through there. Hello?
Advocate Lambani, we're told, is on the platform. We're asking you to switch on your mic and your video and talk to us.
His name is Edward Mus. Yes.
Is there an Edward here on the platform? Okay, what we will ask of you, Chairperson.
He's speaking, but he's muted. He has opened his video.
Is
Can unmute.
My apologies. Yes, I was muted. My apologies, Chairperson.
Okay, we Advocate Lambani. I'm sure you have been listening, and you appreciate our difficulty that we have with the identified official from the university. That is not been very helpful to this inquiry, and we want somebody senior to answer the question, and you as the registrar are a relevant person to answer the questions that you have. If you are not able to answer the question, some of the questions, you are free to say, this one I'm not able to answer to the best of my ability. The same way as the chair of council did, and which was fair for him because some of the matters happened before him. Are you able to help us, Advocate?
Honorable Chairperson, let me say immediately that I was not sitting all along. I was called in an emergency with the SRC students. I just came in, and I may be able to help wherever I'm able to help. So I wouldn't definitely guarantee that indeed I will be able to help. But where I have the answers, Honorable Chair, I will definitely give it to the committee.
Okay, maybe if you can just give us an indication, when were you employed as the registrar of the university? Since when?
I was employed recently, Honorable Chairperson, only from the 1st of December as a registrar, but from 2020, 1st December, but from 1st of October 2019, I was appointed acting registrar.
And before that?
Before that, I was the Director of Legal Services from 2014.
Okay. So you were there when most of the things which are part of the inquiry were happening. So you were holding the position of the gentleman who came before, who was not really very helpful.
Correct, Honorable Chair.
Okay. Maybe let's try with you, Registrar. And if you are not able, we'll just have that question stay over. But before you can give any evidence, there will have to be an administration of the oath. And it's going to be done by our legal services, Mrs. Ngema, who's going to help us. I'm not sure whether Mrs. Ngema, you are still on the platform.
Chairperson.
Okay, let's administer the oath to the registrar now.
Thank you, Chairperson. Good afternoon, Sir Lambani. Will you kindly give us your full names and the position you currently hold where you are for your employment purposes for the record?
I am Edward Nkangwereni Lambani, the University Registrar of the University of Venda.
Thank you, sir. I'm now going to administer the oath and explain its processes. You are required to take an oath in accordance with Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004. You are now required to appear before this committee as a witness and to answer questions related to allegations on the inquiry into the appointment of Professor Mbati as Vice-Chancellor and related matters to the University of Venda. Please be informed that by law, you are required to answer fully and satisfactorily all the questions put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers and Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or Committee of Parliament with information or makes a statement before it, which is false or misleading, commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm the evidence you are about to give is truthful. You may choose to either take an oath or make the affirmation. Which is it that you prefer?
I prefer both.
Thank you, sir.
Okay,
Please
sorry,
raise-
Ngema, as you administer the last part of the oath, can we please request the registrar, when he responds, to raise his right hand, sorry.
Yes, Chairperson, thank you. Please raise your right hand and say these words after me. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth, so help me God. With your hand raised.
I say that the evidence that I shall give shall be the truth and nothing but the truth, so help me God.
Thank you, sir. Thank you, Chairperson.
Thank you very much. Thank you very much, Mrs. Ngema. Thanks for your assistance. Advocate, there are a couple of questions which have been raised by Honorable Tambo to the Chairperson of Council, who then asked that the Director of Legal Services must assist. But as I said, we did not get that assistance. Now I'm going to go through some of the questions again. The first one was the relationship between Professor Mbati and Andani Holdings. The allegation is that there is a relationship. Andani Holdings was appointed by the university for some work there at the university, and then he's related to it. So I'm going to ask, maybe if I can take it further. The allegation is that Professor Mbati was a director or is a director of Black Capital, which was a subsidiary of Andani Holdings. Can you confirm that he is or is not a director of Black Capital?
Honorable Chair, I can't confirm whether he is or not. I'm definitely not aware.
And then whether Black Capital has got a relationship with Andani Holdings, can you confirm that or you can't?
Chair, I would also not confirm that, but I must state I knew not much, a little about Andani. I can't even call it whether it was holding, because they were engaged with one of our unit here, the University Innovation and Growth Development Company, which we call the UIGC.
Okay. Do you know the directors of Andani Holdings?
No, not exactly.
Okay. All right, maybe let's not continue with that, because you don't know much about Andani Holdings, its directorship and its subsidiaries. maybe let's go to the issues of utilizing university resources. Now, a couple of the witnesses made an allegations to us that Professor Mbati was allowed to use the university funds to defend himself on the sexual harassment matter in particular. Now, maybe if I may just expand on that. In terms of the minutes of council of external members of the 17th of April 2015, council recommended that there must be a task team which must investigate if there was appropriate use of university resources in respect of the VC and principal in the defense of the matter. There is a JCE, but there's other matters as well. Now, we put this question to the Director of Legal Services, but he was just all over the place, but we would like to get the specifics. In your knowledge, did Professor Mbati utilized or appointed legal representatives or lawyers to defend himself personally using the resources of the university? That is the first question. We'll get to the task team because we're interested in understanding whether the task team was put in place and what was the findings of the task team in relation to that allegation. So can we start with the first one? I know that it's a bit general, but is there in your knowledge the attorneys appointed by Professor Mbati to defend himself because he was accused individually that he did something? He was not accused in his capacity as the VC. So are you aware of the costs that were incurred for the legal cost, whether was it for the university or was it for him?
To the best of my knowledge, I was responsible for the legal division. He never used the lawyers that we were using for the university. And there was no money that was paid for his own personal things. Even the council members, I think they used to also ask to see the costs that are being incurred on the university work, not on his matters. As far as I'm aware, he never used any of those lawyers we used, nor used the monies allocated by the university for legal costs.
Which attorneys did you use?
When I joined in, the university had a law firm called Boyens Manewick. They used to do civil matters for the university, everything civil, litigation, whatever. And then on labor matters, I found that they were using Bowman. And there were number of other lawyers who were used because they were using a database, but those were key in that these two areas were the major areas for the university.
Okay, and which lawyers were used by Professor Mbati?
Chair, I would be guessing really. I wouldn't know the specific names, but he never used Bowman. No, Bowman's, Boyens and Dupre, Boyens and Manewick. Those were the university lawyers.
If I were to put to you, Registrar, that Professor Mbati used Bowman's as the lawyers that he was utilizing to defend himself, what would be the comments?
I would definitely not say it is true or not true. I may not know the relationship that you could have had with the firm, but the ones I was using, the specific people, were specifically just on the university work.
Okay, now we received a letter from Bowmans just before we started with the process of this inquiry. Now I will have to verify whether were they acting for council or were they acting for Professor Mbati. But Bowmans, as far as I could see the records and the correspondence, acted for both the university and for Professor Mbati. That is the information that is at my disposal. What did you say to that, to the statement that you made that he never utilized that?
Chair, I'm honest, I never utilized anything for his own personal issues. So I wouldn't even know the correspondence that we are having. And I wouldn't say it is incorrect because really I never wanted to get in between his own personal issues. I was extremely careful to ensure that there's no confusion if he is dealing with his own matters, that we as a university end up paying also for his own personal issues. Okay.
No, it's fine. We might have to ask you to come back for that, but we will further probe that issue. So the issue of the chairperson, the presiding officer in the disciplinary inquiry of Professor Pendler, there is an allegation that it's a personal lawyer of Professor Mbati.
Chair, I don't even know because I think that was done even before my time. I can only check the records who were the presiding officers, but I was not as yet part of the university when that happened.
Okay, are you aware that there were some issues about ethical conduct that were raised against the lawyer at Bowmans, who was handling matters of the university and of Professor Mbati?
I'm not aware, Chairperson, not at all.
Okay. Well, we'll come back to those issues. I think it's the records that we have. The last one is the settlement proposal, which the question which was asked. I can't remember how Honorable Tambo put it, but there was a settlement proposal that was put on the table by Professor Mbati on behalf of the university when the matter was at the Labor Court. Are you aware of that?
Chair, I was part, I'm actually the one who made that offer. It was not a letter, and I don't know how to put it, the chagrin of Professor Mbati, because it was not by agreement. When I was here, we were looking at the length of the matters that are going on there. And I happened to know Professor Pendler personally, not because of employment. And I felt maybe the matter could be settled out of court rather than continuing, not actually settling on his behalf, because when I hinted it to him, he never even agreed. And I only had the support of his director. There was his director in his office called Dr. Chipereke. He's still my friend, he's close to me. So we discussed the length of the matter, that even though it is against the university, maybe there could be a way of settling in order to obviate the escalation of cost. And we also discussed with Dr. Zaiman, who was also the GVC for operations. He was responsible for the payments of the legal costs for the university. And we had thought if it is settled, it would really curtail the university going further. But The problem was that the case was intertwined to him because personally, he was actually the one being accused, though it was the university that was being taken to court. So we hinted that kind of settlement, and I discussed it, but Chair, I must say, we were requested for a copy of a letter. There was no letter that was ever drafted, unless if the lawyers did it at a later stage. But when I discussed, there was nothing written, but I even discussed with Pendler to see if the university cannot settle the matter to obviate the escalation of costs. And it was never proceeded with.
Okay. All right, thank you very much.
Chair, just to confirm, apologies.
Yeah, Honorable Tambo.
The settlement offer, in what capacity did the registrar make it at the time? As a personal friend or as a representative of the institution?
I was doing it as a representative of this institution, Honorable Member. I was responsible for the legal services. I felt it is part of my responsibility if there's a way of settling certain issues, rather than allow matters just to drag on because somebody's right somewhere, whatever. If there's a way to settle, to obviate escalation of costs, and it would be better for all, that's what I thought.
Okay, thank you very much. Maybe let's move. Look, Registrar, I think you are much more helpful than your colleague. There are questions that remains unanswered, and I think we'll come back to them. But there is just one before we step off, which I don't want us to forget about it. The outcome of the task team, which was commissioned by Council. Do you know what happened to the task team and whether there was a report about allegations of inappropriate use of resources of the university?
Chair, if maybe I can be reminded, I'm not aware.
On the 17th of, it's on the document, it's page 6 of the minutes that you furnished us of Council. Is document PCH 10, page 6 of the minutes of the external council, external members of council on the 17th of April. It says that there was a recommendation by council that the task team should investigate if there was inappropriate use of university resources in respect of the VC and the principal in defense of the matter. That is regarding the CGE report review. So now, obviously, council suspected that there might be something which was wrong, which was happening, and that there might be inappropriate use of the resources of the university by the VC. Now, we don't have a report of the task team. Are you aware whether the report was ever finalized, and what was the findings of that report?
I'm not aware, Chairperson. I don't even recall that task team ever submitted a report. And as you read it correctly, the task team was established when they met together as only external members of council, and we were all excused in those meetings. And even the report bag would be excused from those kind of meetings. Definitely, I'm not aware of any report coming from that task team.
Okay. So I guess the chairperson of council at that time will be able to confirm to us what happened to the task team report and what was the findings. Okay, we're done with the questions of Honorable Tambo. Of course, if there are outstanding ones, I know that some of them may not have been responded. Please take note of that, and then we will then determine way forward after that. Honorable Boshoff.
Thank you, Honorable Chair. My questions are, of course, to Professor Makgatho. These are just two simple questions in the light of his testimony, as he also presented it this morning. Would he regard this inquiry into the whole question about Professor Mbati as a form of malicious prosecution, or if it's not prosecution, then at least malicious inquiry? And then the other question I have, which he may say he didn't appoint himself, but could he maybe just give us an idea why he would be appointed chair without having served on the board before? Or have I understood that incorrectly? I understood that he said he was only appointed on the board in the middle of last year as the chair immediately. Was there a specific reason for not appointing somebody with a little, to provide a little bit more continuity? That is all. Thank you, Chair.
Thank you, Honorable Boshoff. Those are the two questions. Now, I'm having a bit of a problem with your first question, because your first question relates to the intention of the portfolio committee for which you belong to resolve to institute this inquiry. And you are asking an external person to comment on whether they think this is malicious or is genuine or not. I'm not sure whether it's appropriate for the committee to do that. This is a decision of the portfolio committee which we are proceeding with, and we have invited the witnesses. So I wouldn't like us to put that question to the witness.
If I might just respond, Chair.
Okay.
I'm fine if you don't want the question to serve. What I was actually getting at is that it, every allegation or every statement which was made was denied with such absolute resolve by the chair that it might seem as if there is no base for an inquiry. While I think the other evidence that we have suggests that it does. So I was just concerned about how does Professor Makgatho respond to the whole process that we are busy with. But if you don't want it to serve, it's not a doubt from my own side. It's just that it all seems so squeaky clean if you listen to the chairperson of the board. That's why I asked the question. But I'm fine if you want.
I understand where you're coming from. I understand you, Honorable Boshoff. I just don't like us to put questions to witnesses that will then force the witnesses to evaluate the decision of the committee. Because if we do that, we are then inviting the witnesses to say, do you think the decision by the portfolio committee is malicious or not malicious, whether it should have been taken or it shouldn't have been taken? Because we're inviting witnesses to evaluate us, and that's not why we're here. If there is any concern about whatever that we're doing which is not proper, I think members of the committee have got a right to raise it within the committee itself and to debate and to have a conclusion. I can guarantee you that every person that we invite to the portfolio committee, they would prefer not to come, because this is a forum to conduct oversight, to ensure that people are held accountable. And the process of holding people to account is not an easy process. I don't think anybody else will come if they will give them an option whether you want to come or not to come. So I would like us to avoid that one. But the second question, I think, is in order. We should ask the chair to then respond to that appointment of the chairperson. Can you respond to that, chairperson?
Thank you, Chair. I've always had work that I was involved with the university. I was an external member of the audit committee of the university. I also chaired, helped establish a risk management committee for the university. I have over 20 years board experience, both in the private sector and the public sector, and I'm a businessman in my own right. Obviously, when the term of the previous council came to an end, I was nominated to serve on the council through the minister, and the members who were then appointed to be new council members saw it fit that I should become the chairperson. So we voted by the members.
Okay, thank you very much, Honorable. Thank you very much, Chairperson of Council. Honorable King.
Good morning, everyone. Thank you, Chairperson. I only have a few questions. The first one is that the Higher Education Transformation Network actually wrote to the Portfolio Committee on the 13th of May, raising concerns on the unfitness of Professor Mbati to hold the office of the Vice-Chancellor. So when we consider that, I just needed to find out if there were any deviations that was made regarding the human resource management policy processes during the interview on the appointment of Mr. Mbati. Also, if you were to consider that Professor Mbati actually used his own legal representative in the disciplinary case against Professor Pentla on the 1st of November 2011. I just wanted to ask again, would you say that the professor actually used the University Disciplinary Committee to get rid of some of the staff at the institution? Because when you read about it, there was complaint leveled against Professor Mbati to say that most staff, senior staff, left because of his actions and him interfering in the disciplinary processes. Then also Professor Mbati was then asked to leave according to staff members' views a day or two before the disciplinary or mitigation processes take place. Would that then not have affected or influenced the outcome of the mediation process going forward? Then when it comes to the money spent on legal cost, there was a special council meeting on the 27th, in September 2017, where it was actually reported that 18 million rand of the university's budget was utilized by Professor Mbati to fight legal battles to defend personal litigation against Professor Mpandla's sexual harassment case. I just needed to find out if you are aware what was the outcome after they were made aware of this exorbitant cost of legal fees being used for personal gain by the professor, and what actions was then taken against the professor in that regard, considering that we see that almost more than 109 million rand on legal costs since 2010 to 2020 was then spent. And if you were to consider the legal cost, was there any way that they could have avoided these legal costs that was incurred against staff members in the long run? I'm talking clearly on the university's side. Let me just go to my questions.
Honorable King, just for my own assistance, are you picking up that info from the questions? If yes, can you just refer me so that I would like to get background info because it's quite important.
No, it was in one of the documents that was sent to us, actually the letter that was sent to us by the transformation network to the portfolio committee. So when I read through that, I actually found this information.
Okay, no, it's
So
fine.
it's not actually, I just linked it to the
Yes.
questions.
No, it's okay.
Okay, and then the last question that I would like to know, when we consider the sexual harassment policy of the university, how often is that sexual harassment policy reviewed and amended? And when we consider the prescripts in the sexual harassment policy, can the council satisfactorily say that they have exhausted all avenues regarding the sexual harassment policy when it came to the sexual harassment case of Professor Mpantla? And then also, if you consider the appointment of the Vice-Chancellor, when you also read in the documents, it basically says some Senate members were not aware, they only found out on the day, or some of them actually only found out when us as the committee made them aware that there was a sexual harassment case. So how could a professor be given an appointment of Vice-Chancellor when there was this case pending, or was his appointment done before the court case, or was his appointment done after the court case, meaning you had to wait for the court case outcome before you appoint him? Chairperson, that's all. Thank you.
Okay, thank you very much. Chairperson of Council.
Thank you, Chair. I'm not sure which appointment the honourable member is referring to. I suppose that relates to Sefako Makgatho, not to Univen.
Yes.
Okay. No, that will be in part.
That could be something else, yeah.
That
Thanks.
will be part B. This is part A of the inquiry.
Yeah. I think the one that I can refer to, the sexual harassment policy, we are actually at the moment, since I became aware of this matter, the sexual harassment policy, together with a lot of policies relating to gender issues, are being reviewed at the moment. We have a subcommittee of council which is charged with HR matters, and we are pretty sure that our policies, once finalized, will be up to date and up to par with what are the expectations of this country. On the question of legal costs, I'm pretty sure the legal counsel will be able to answer that together with the registrar, together with the Professor Mbati leaving before his expiring spare of his term. Registrar?
Okay, are you done?
Yes.
Okay. You were talking about legal costs. Sorry, man, I got distracted.
Okay, I'm saying on the question of the legal costs and those relating to the professor leaving before the termination of the expiry of his term, I'm sure the registrar will be able to deal with the matter.
Okay, and then the sexual harassment policy.
What I'm saying, we since this matter came to my attention, the subcommittee of the council that I'm now chairing has been given a task to review our sexual harassment policy together with GBV policies and all gender-based policies to make sure that they're up to standard, they're up to par with expectations of this country.
Okay. Registrar, do you want to add on that?
Thank you, Chair, Honorable Chair. I really wouldn't know where to add, but I don't think there's anything to add because the issues of the legal cost, Chair, I think I've responded to that. And the leaving of the Vice-Chancellor before the DC, I'm definitely not aware. But when I joined the institution, I think he was now in his second term and he left when it has expired.
Okay. There is an issue that I think we'll have to come back to. The allegations that the presiding officer in the disciplinary inquiry of Professor Pendler is a personal lawyer of Professor Mbati. We have to come back to that. There are other witnesses who are going to come, but we also want to probe this with the former chair of council, Mrs. Mabusela. There's also an issue about the sexual harassment policy, which the registrar will not be able to answer because that is the duty of council. And the current chair of council was not there when this happened. He can only talk to what happened after, that they are establishing a subcommittee or a task team to review and all of that. Now, all these questions, we need the chair of council, the previous one, to answer for it, because this is at the crux of this inquiry. Whether or not the University of Venda did implement to the fullest the sexual harassment policy. And the information that we have suggests that the university did not do that. The university had to be directed by the court on the review application that they've lodged on the CGE report. The court had to say implement section, is it 5.1 or 6.1 of the sexual harassment policy, and hence council, after that court judgment, then requested the report from Lavari Modise. But council on its own did not have the appetite to implement that sexual harassment policy, and we want to find out why. Why did council not have the appetite? Why did council not implement this policy? Because the policy has got a two-stage process of dealing with sexual harassment. First, the mediation, and if the mediation doesn't resolve, then there is another process that must kick in, which process did not kick in until the court had to instruct that way. So that information we'll get it from the chairperson of council. I think if we are fine, we can move to Honorable Litsie. I don't know if you still want to come in. Yes, it's Honorable Litsie. And then
yes, you can, can I continue, Chair?
Yeah.
No, thank you very much, Chair. And the point that you were just making, I think that is where my question is on the implementation of the university's statute sexual harassment policy. The chair of council, when reading his witness statement, there was a point he made, and he said, council decided not to take further action, meaning on the sexual harassment, because the courts, Professor Pendler had lost the case in court now. And I think, Chair, you almost covered me now towards the end of the point you were just making. But I want to ask the Chair this question, because he mentioned it in his witness statement. So I think it's relevant for him to respond. One, paragraph 3 of University of Venda's policy on sexual harassment state the following. Open quote, the university is committed to promoting a working environment in which students, employees, and other persons who have dealings with the university are protected from sexual harassment. Close quote. The previous chair of council would have also revealed, and that is something you also said in your witness statement towards the end. But Mrs. Mabusela would have revealed that Prof. Pendler was facing charges of corruption and was subjected to a disciplinary process. during the disciplinary process, Prof. Pendler submitted a grievance to the previous chair of council, Mrs. Mabusela, indicating she was sexually harassed, and then by the then Vice-Chancellor and Principal of University of Venda, Prof. Mbati. Paragraph 5 of the University Policy on Sexual Harassment states that, open quote, anyone who feels that he or she is a victim of sexual harassment has the right to seek redress without prejudice, close quote. Upon receiving the grievance of Prof. Pendler, the previous chair, Ms. Mabusela, convened council meeting to consider the grievance, and subsequent processes are also detailed in her response. One, are you aware, as the now, whether any support, either psychological or in any other form, was given to Prof. Pendler in making the work environment for her bearable prior to her dismissal? If so, what kind of support did Univen offer, and if not, why? I think, Chair, but I also want to ask maybe this question to the Chair, because the rest will be to former Chair of Council, Mrs. Mabusela, but to the Chair. Do you, having you're saying a task team now to review the sexual harassment policy, it means you might have went through. Having looked at this specific case, do you think, is it your personal opinion that the council, the steps that council took at that time were correct in waiting for the judgment to finalize, and then only coming back to that part, to the implementation of the sexual harassment, or lack thereof, of the implementation of the sexual harassment? Do you think they were correct in doing so? If not, why not? Thank you very much, Chair.
Okay, thank you very much, Honorable Litzia. Chairperson.
Thank you, Chairperson. I think I appreciate the phrasing of the statement. If I was in a position at the time, I would have said the same words. Unfortunately, this is after the fact. When I came in and looked at what was there, and I said, well, let's review and make sure that we are up to the best standard that we be setting. I'm not very familiar with the actual details of the deliberations that happened at the time, because if I was in that room, I would be able to answer your question. What I'm seeing was just the end of the case, the matter being concluded one or the other. But how we got to build up to that, I think it's a very difficult matter for me to judge. I can talk about what our view is now as the current council, that we view this matter seriously, and also we want to make sure that these type of incidents do not happen again.
Okay. So the question was, were you aware of any psychosocial support that was provided to Professor Pendler?
I could deal with those. I did know those. I thought the honorable member did say this will be reserved for the then chairperson.
Oh,
yeah.
Okay.
I'm not aware of any of these supports that she's mentioning. Maybe the register academy. I'm not aware of them.
Okay. No, I think that should be for Mabusela, because there's also a question of appointment of Maserumule, the lawyers. After the complaint was laid to council met and appointed Maserumule, and we don't know what has happened to that. The records of the appointment we have not been furnished with, and those are the questions for Ms. Mabusela. to come and answer. Maybe let's just leave it at that. I'm sure Honorable Lizie would also agree that it might be difficult for the current chair to respond to that. I think we need Mabusela to come and tell us about that one. Now, let me just pose my question. And I really would like Chair to listen very carefully, because I'm going to make a statement or a comment and then put a question. Now, on the 8th of July, 2016, the council resolved, and I think it's contained in the minutes of a special council meeting, that one, council resolved to accept the following findings of the Modise, who was the mediator, and Mashekho's report as follows. I think you also mentioned to Mashekho. A, that Professor T.S. Chivase Pendler and Professor P.A. Mbati had a consensual relationship. B, that there was no basis for Professor T.S. Chivase Pendler's complaint that Professor Mbati sexually harassed her. C, there was no prima facie case of misconduct. 2, council resolved to close the matter permanently. 3, that the chairperson should communicate the council's decision to the Minister of Higher Education and Training, Dr. Binzi Mande, as he had previously written to the former, requesting him to ensure that council settles the matter between Professor Pendler and Professor Mbati. And so from the reading of this resolution, it's quite clear that the council accepted the report of Professor of Mr. Modise and Mr. Mashekho, which report of Mr. Modise was saying that Professor Pendler and Professor Mbati had a consensual relationship. Now, the question that I have is that in the view of council, do you consider it to be ethical for Professor Mbati as the Vice-Chancellor by then to have a consensual sexual relationship with his subordinates? Are there policies in the university that talks to this? The second point that I would like to make is that we have evidence, and I think it's a point that I raised with the gentleman who couldn't be of assistance. We have evidence in our possession that points to the fact that Professor Mbati, we're still not sure whether he utilized the resources of the university. This is a matter that I think we still have to verify. Took the report of Mr. Modise on review in the Venda High Court. Doing so, he cited Mr. Modise as a respondent, Professor Pendler, and the University of Venda. So he was litigating against his own employer. So he cited them as respondents. Our evidence also points to the fact that the university did not defend its own report, the report of Mr. Modise. The very report that the university used, let's say for now, to exonerate Professor Mbati, because it is the word that we used, Chair, when you responded to this, you said he was cleared by the university. So he was exonerated. So the very report that the University Council used to exonerate Professor Mbati was be taken on review. The university was cited, but the university did not defend its own report. And therefore it was left to Mr. Modise, who wrote the report at the request of council, to propose an explanatory affidavit to explain to the court what the essence of his report is. And it's quite clear from that explanatory affidavit that his version and the version of Professor Mbati were not the same. Quite a number of matters which they differed on. Now, Mr. Modise did not defend, did not oppose that application. And I'm sure that he did that because of cost, because had he opposed, he would have had to appoint the advocates and everybody, and if the judgment was against him, he would have been. So there was a cost consideration. But there was an explanatory affidavit, which we do have, which is in our possession, that talks to some of the issues that were raised, and he differed with them. Now, the question to council, one, is that why did council not defend its own report? The very report that it used to exonerate the Vice-Chancellor. And this was not an easy decision because it was in a special council. There were issues of sexual harassment against the Vice-Chancellor. The council then looked at the report of Mr. Modise, report of Mr. Mashego, and on the basis of that, then came to a conclusion which benefited the Vice-Chancellor. And when this report was taken on review, council did not oppose that. So why did council not oppose that report? The very report which it used as a basis for its own decision. Now, don't you think, Chairperson, that for any reasonable person, or any reasonable person can conclude that there was a collusion working together between the Vice-Chancellor and the Vice-Chancellor, the Vice-Chancellor and the Council at that point? Do you think, that is my third question, do you think that it is ethical and legally justifiable for Professor Mbati to benefit from a generous decision of council to exonerate him from allegations of sexual harassment? Whilst, on the other hand, he challenged the very report which was the basis of his exoneration by council. Do you think it's ethically and legally justifiable? Because it can be viewed as a person having his bread buttered on both sides. You benefit from a generous decision, which benefit Professor Mbati is still utilizing today, that he was cleared by council. And that clearing refers to a meeting, that special council meeting. But then that very report was then taken on review, and it was not, the council did not oppose that. So can you please answer the question? First of all, I'm asking this question not because I accept the decision of council, but I want to find the logic, because we know that there was never a process that allowed the interrogation of the facts regarding the allegations surrounding this, the cross-examination of Professor Mbati and all of that. But what we know is that there is a report of Mr. Modise, which was then taken on review. Can you please answer some of these questions? And I think there are 4 all in all.
Thank you, Chairperson. Obviously, I'll answer those that I think are straightforward. There are those that have to be referred back to the actual chairperson at the time of the day. The very cardinal point that you made is what I call power play, power relationship. For me, it's an ethical relationship with any of your subordinates, particularly if you are in a position of power. So that one I can deal with absolutely. That as far as I'm concerned, it's a no-no. And in the new policy, I think we ask them to actually look at that. That it should be a very clear cut case that that type of relationship should not be tolerated and should not be approved completely. The abuse of resources, the review of the judiciary report, and also the non-defending of that report by the university. I believe at the time maybe there's some facts information that I'm not privy to. It's a good question. I suggest that we reserve that for either Mr. Maja, who was the chairperson, or prior to that, Ms. Mabusele. Thank you.
There were other questions. In your own opinion, because I'm asking for your honest opinion. Don't you think that any reasonable person will conclude that there was a working together, there was collusion between the Vice-Chancellor and the Council on this matter of sexual harassment allegation? Because for me, it does not make sense that we use a report as Council to clear somebody, to exonerate him. And he benefits from that exoneration because no action is taken against him. Later on, after he benefits from that, he goes to court, challenge the very report which was the basis of his exoneration. And we as Council don't do anything about it. We don't defend. So what does it say to Council, to me, to an ordinary person, that here is the Vice-Chancellor working together with Council to make sure that this matter has been dealt with in the way that they want? Wouldn't that be a reasonable conclusion that any person would make, including ourselves as the portfolio committee?
Chair, on the face of it, I'd agree with you. But again, because I don't really know the full facts behind those type of decisions, I prefer that the relevant people, I think, put their matters to yourself, and then you can be the judge. But on the face of what I know, I would not agree with the process that was followed. But again, with this proviso that I am not fully empowered with the facts.
Okay. The other opinion that I would like from you is that Professor Mbati takes the report, which is the basis of his review, to court. So on the one hand, he is a member of Council, so the decisions that are taken by Council, he would be aware of those decisions. And one key decision is that no action must be taken against him because the Council has accepted on the basis of the 2 reports that there was a consensual sexual relationship. It's a conclusion that Council is making. Now, on the basis of that, then they take a decision to let him go. No action taken against him. And then he goes to court. He challenges that report. of Mr. Modise, but then he does not challenge the decision of council. Don't you find it weird that that is the case?
Chairperson, I think it's weird, but I think maybe the registrar can, because I think he was there at the time, he can give us an answer to that, but it is pretty weird.
Okay, and to add it to this, to top it that, so the court which directed that that report must be produced, it is the, I can't remember whether it was the North or South Division of the Gauteng High Court.
Maybe not.
It was in Pretoria, yeah. It was the Pretoria High Court, which said that, which looked at the review of the CGE report as brought by the university, and which concluded that the report by the mediator must be produced. So now, when the report that has been produced as directed by the court in Pretoria is challenged, it is no longer challenged at the court which issued that order. It is challenged at a different court, which is the Venda High Court, which does not have a history of how this matter was dealt with and what happened. And the university also does not oppose. So he gets a what is this? Default judgment, because the matter is on an unopposed roll. What would your comment be on that? On the person of the VC who does that, and of course the university is involved in that matter.
Look, I think it's a matter that maybe we should also try and look at as a university so that we can learn from that, what actually transpires, what really led to that type of decision. I can only say that we should learn by getting more facts. And I'm happy that the registrar is sitting in these discussions, and I'll raise that with him, that maybe we should make sure that they will fully understand the background to this matter.
Okay.
It's a matter, and I think we as a council can substitute to get back to you to say this was the basis of the decision. But I think the first pass for you is to get it from the horse's mouth, the two chairpersons at the time.
Okay. All right, maybe I'll also speak to put some question to the register. Now, we have received a statement from Professor Mbati, and Professor Mbati has been making comments in the media. He will come here. I'll also put this question to him. According to him, he says, and he has been claiming that he was cleared by council. He was cleared by council, and this clearing by council refers to the meeting of the 8th of July, 2016. So this was a key decision. So on the one hand, he was cleared. So if you say I was cleared by the decision, it means you accept the totality of the decision. And the totality means that there was an acceptance that there was a consensual sexual relationship, which you must accept. On the other hand, you deny that there was no such a thing, which was the basis for him to take the Lavare report to court. So we don't know when we are seated here, which one is which, and which one is the position of council. But maybe let me get the registrar to comment on that, on the reasons why council did not oppose. I know it was not your decision, registrar, but maybe you can shed some more light on that one.
Thank you, Honorable Chair. Indeed, it wasn't mine, but as you started by giving that summary, I think I'm in the same position as my present chair. At that time, it's true what you have said, but I think the council had accepted the report and believed that they should take that particular decision. And when it came to challenging the review, I can't recall, Chair, and I would just be talking out of my own mind, but the council members, I think maybe those who will come will still clarify, we're happy that there was this conclusion which they received from Modise, but seemingly the Vice-Chancellor, Professor Mbati, did not agree, though, as you say, he was part of the council, which indeed had come to that conclusion. I wouldn't be against your thinking on this matter, Honorable Chair, but there was nothing that was said to legal, please go ahead and oppose, because they felt they stand by that decision of Modise, and they would abide the decision of the court.
Okay. Yeah, well, we will ask the members of council, because for me, it does not really make any sense. You take a decision based on the report, but when that report is been reviewed and set aside, you don't defend it. And I think that's where some of the some of our suspicion come from, that it does not make any sense at all, not to anybody, that this could have been the case. So we will get it from the chair of council. Can I get, I think Honorable Mananiso had indicated that she raised her hand. Can we pick up? Are you still on the platform, Honorable Mananiso?
Yes, Chair.
Okay, go ahead.
Okay. Thank you, Chairperson. And I would want to commend you and the men who are in this particular session that you have responded to the call of every woman in South Africa, of Men to the Front. And I think now everybody would get sense how important it is, this particular case. My question, Chair, to the chairperson is that I want to know, because of when he was making his input, he indicated that there's been many questions coming to the institution with regards to Prof. Mbati. So I want to know how many people have been writing to the institution with regards to the reinstatement of Prof. Mbati, and are those people responses satisfying in terms of what they wanted to get from the university? And the other issue is with relating to question 1.5, to say that when we go through the report, there's some indication with regards to people who were supposed to be reinstated, who were dismissed by Prof, that are those people still within the institution, or what is the status quo thereof of those who were successfully awarded to be reinstated? And lastly, Chairperson, it's I think you have covered me on the issue of consensual relationship, and I just want to check with the council to say, beside this case of Prof. Mbati, are there any cases like this one where all these things, when they come of sexual harassment, then people will then resolve to this casual way of responding to them, that people had consensual relationship? Because according to me, knowing the policies of institution, and relevantly to this one is the fact that the conflict of interest, it is discouraged at all cost to save the institution. And lastly, I want the chairperson to answer me with regards to the terror and horror of this particular case, to say, what is his plan to ensure that he brings back, as the council collective, they bring back the dignity of the Univen? Because for me, if people are failing to deal with such issues based on merits, and they tend to take some decisions that suit other people whom the report indicates that they've been misusing their power. It takes away the issue of leadership in the institution. So I want to know what is it that they will be doing differently as the university to ensure that they become consistent and they don't sway the policies that they have abided by as the institution.
Thank you, Honorable Mananiso. Chair.
Thank you, Chair. I'll respond to the best of things that I'm aware of. The issue regarding communication regarding the previous matters, those who were dismissed, or regarding the appointment or position of Professor Mbati with the Univen, I don't think I'm aware of any of those type of correspondence. Maybe they've come through to you, but I suspect, don't remember this, I'll refer this matter maybe to where he is now, Sefako Makgatho, in institution, university. The issue about consensual relationships, I think I did make my point very clear about that. That to me is a power relationships are totally unacceptable, and they do lead to a number of issues. One of the companies that I worked for many years ago is that any of the matters where even a relationship is seen to be existing between senior member and a junior member, one of them is asked to resign. And that has happened most of international companies that I worked for. And I believe those are some of the things that we should be looking at to avoid these type of things. In terms of policy matters, I think it's important that we make sure that our governance processes and principles are in place, including the issues of sexual harassment and gender-based violence. Those should be taken to the corporate boardrooms, should be taken to all the serious structures of any organization to ensure that they receive top priority. In some companies, they've also put together what they call ethics committees. Those ethics committees look at the issues that have to do with this type of matters that could create conflict, that could lead to undermining of authority, and this all leads to that. So I believe we are looking at most of these issues in this current term. Thank you, Chair.
Thank you very much, Chairperson, and I did not record that Honorable Mananiso was the last person. Chairperson, Honorable Mananiso, I think she's indicating that there is a question that was not properly responded to, which was to say, as the portfolio committee, are you aware of any queries that were brought on or against Professor Mbati?
I'm not aware of any other queries except what we're dealing with now.
Okay. Okay, let me just make this comment, Chair, and I would like to get your comment from you. Now, from the information that is available at our disposal, it appears to me that the Council of the University of Venda was reluctant to deal with the allegations of sexual harassment that was brought by Professor Pendler against Professor Mbati. irrespective of when was it brought. And for me, I don't really like to entertain that question, that at what point, because these are some of the decisions that are made by those who think that they may be violated. It is not for us to say, why didn't you bring allegations of rape or sexual assault the day after it happened? Why did you wait a week? Why did you wait a month? Why did you wait a year? So these are not the questions that we should be asking. Because it depends on the person who feels that she has been violated. She can come immediately, she can report the case to the police station immediately. She can wait for a day, she can wait for, depending on her own personal choice and circumstances. So it is not for us to say that, because we were told that when we begin to ask such questions, it becomes a secondary violation, that the person has been violated according to her view. She's bringing a matter. What you have to do is to follow up. And so the policy was very clear on what needed to be done to investigate that sexual harassment. Now, it appears to me that what needed to be done were not done to the fullest. At least we can credit the university that when the matter was raised with the chairperson of the University Council, the council appointed a mediator to mediate as per the policy of council, that sexual harassment policy. But then when the report of the mediator came, Mr. Lavari Modise, that the matter became inconclusive because he could not resolve it through mediation. The next step, which was supposed to kick in, I think it's 5.1 or 6.1, was that formal processes were supposed to be engaged with. The council was supposed to investigate and charge the person against whom allegations are made. And it is for that person to clear himself through a due process. So when allegations are brought, you check the veracity of the allegation and whether they've got merits, and you institute a process, and then that person has to clear himself against any allegation through a due process. And a due process means that evidence has to be examined. A person alleging must come and say, this is what has happened. The person against whom allegations are made must also present, and there must be an independent evaluation of the facts. So that is what is called due process. Now, in this case, council did not want to act. And from what we are picking up, there were, some flimsy reasons given why they couldn't implement their own policy. That the case is investigated somewhere, that somewhere the matter has been held. But what is the responsibility of council? Is to implement the policy that they have. So they did not do that until there was a CGE report. They were not happy with the fact that the CGE says that there was sexual harassment. And they took that CGE report. And then there was an out-of-court settlement which was made an order of court. And they then agreed that, okay, as council will then do our job, we will call for that report of Mr. Modise in terms of 5.1 or 5.6.1, I can't remember the exact clause. But that clause says you must call for the report with the findings and then take the matter from there. And taking the matter from there would have meant that Professor Mbati was supposed to be charged, which is something that council was reluctant to do. It had to waste the resources of the university, go to the Pretoria High Court, to set aside that report because it makes adverse findings against Professor Mbati. And so that court, through agreement, it was then certain parts were excised, but not the recommendations, but the recommendations remains as they are. And in fact, it was the ruling of the court that that matter must be, Lavaris report must then be requested. When it comes, council uses it to justify why it is clearing, exonerating Professor Mbati, accept that there was a relationship and all of that, and then say the matter is closed. Okay, fine. And then its own decision gets challenged in another court indirectly. When the very basis of its decision was being challenged and set aside, council does not want to defend itself. So you can see there is a history of council being reluctant to act on a matter that involves Professor Mbati. That it's quite clear that there was some collusion between the Vice-Chancellor at that point and the council members, to an extent of council members willing to do everything in their power to protect him being taken through a process that will probe whether there was or there was no sexual relationship. Now, from where we are sitting and the information that is at our disposal, that is the version that is coming out. That is the picture that it's emerging about the role of council in respect of making sure that the Vice-Chancellor acts ethically, acts professionally, acts in line with the rules and the regulations of the university. And council failed to execute that responsibility. What would you say, Chair of Council, to this scenario that I was painting at you, to this version that is beginning to emerge very clearly, as far as, say, for instance, some of us are concerned, that this is probable, this is what might have happened in council. What would you say to that?
Thank you, Chairperson. I think you're making a very valid point. One of the issues in any organizations is to ensure that the governance processes are in place and they function effectively and efficiently. I'll talk about myself and what we're doing with the current council. It's to look at those type of issues that relate to governance. Governance is the cornerstone of any institution or organization. Governance is the way of doing things and the way of operations in any business or in any institution. If we don't have those structures, we'll continue to have these lapses. Obviously, we as the incoming council have not questioned some of the issues that we're now raising, but what we can do is to make sure that we have our own process in place and procedures to attend to these matters. For me, I think this engagement is quite eye-opening, and we welcome this engagement so that we can learn from those issues, but move forward to make sure that we don't repeat this again. Thank
you. Okay, thank you very much, Chairperson. And I think we must take this opportunity to appreciate that you did respond to our invitation. You are here. You are responding to the best of your ability. And I think members will make their own conclusion and finding at the end of this inquiry. But I really appreciate the honesty with which you have been trying to respond to the issues and to help this portfolio committee in getting to the bottom of what has really happened there regarding these governance failures, because there are indeed governance failures. which have to be corrected at some point going forward. So I would like to take this opportunity to thank you. I think you have been very helpful to us. Some of the matters, of course, we could not respond to with the authority because they fall outside of your term of office. You are not there when these matters were happening. So let me thank you very much. Let me thank also the registrar. The sense I get, registrar, is that you have been as much as you can trying to help the process to the best of your ability. And I think we'll also want you to come again when we engage with the former chairs, two of them, Mrs. Mabusela and what's the other chairperson?
Maja.
Maja, Mr. Maja. Would also like you to come. Please prioritize it, and I think we will issue out invite to yourself as well. Would like the Vice-Chancellor to be also here, and the rest of the team, the management team. This is a very important inquiry that talks to the governance and management of the university, and I think that there are a lot of lessons to be drawn from this experience. And it cannot just be business as usual when we're busy with this process. They must come here. I would like to thank yourself, Registrar. From where I was sitting, I did not get an impression that you are trying to be defensive or whatever, but you were answering questions to the best of your ability. Unfortunately, I cannot say the same about the director there, the gentleman who really was not very helpful. And I don't know why he was here in the first place, because he offered a lot of denials without being specific. He was ill prepared. We kept on being distracted. Either is the printing machine or the secretary who just going up and down in the office. So he did not really make a good impression, and I think we did not benefit much from his attendance. But otherwise, I would like to thank all of you for coming. I would like to say to the members, I'm sure lots of your questions have not been responded to. And I think that the relevant persons will make sure that they come to respond to these questions. And of course, if questions that we have are not satisfactorily responded to, we as the portfolio committee have got a right to make our own conclusions at the end of this inquiry. So, but thank you very much for participating, members. I think we can call it a day today, and we'll resume again tomorrow at 9 o'clock. Thank you very much. I think our meeting is therefore adjourned.
Thank you, Chair.
Thank you, Chairman.
Thank you, Chair.
Long live the chair.
Long live